Welcome to EUPrivacyForAll, Session 4 on the GDPR adopted and published Article 22, Automated Individual Decision-Making, including Profiling. The Article 20 discussed during the trialogue negotiations was renumbered Article 22 on Automated Individual Decision-Making, including Profiling. As set in the final wording of this article, the data subjects shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her, or similarly significantly affects him or her. Such a restriction shall not apply whenever it is necessary for entering into or performance of a contract between the data subject and a data controller. It is authorized by union or member state law, and it is based on the data subject's explicit consent. In the cases of a contract or of a consent given by the data subject, the controller shall implement suitable measures to safeguard the data subject's rights and freedoms and legitimate interests, at least the right to obtain human intervention on the part of the controller, to express his or her point of view, and to contest the decision. Decisions referred to in this paragraph 2 shall not be based on special categories of data, that is to say, sensitive data, and criminal convictions and offences. A key recital in GDPR is recital 71. It reminds that the data subject should have the right not to be subject to a decision based solely on automated processing, producing legal effects, or significantly affecting the data subject, such as online credit application or e-recruitment, without any human intervention. However, if let down in union or member state law, such profiling could take place for instance, fraud and tax evasion monitoring and prevention purposes, if suitable safeguards are provided, that is to say, a specific information of data subjects, the right to obtain human intervention, the right to express the point of view of data subjects, to obtain an explanation on the decision, or to challenge the decision. However, such measures should not concern a child. Additionally, this recital makes really clear that the controller had the obligation to use adequate mathematical or statistical procedures for the profiling in order to minimize the risks and to limit the number of inaccuracies in personal data. Other interesting provisions in the GDPR come from recital 72. It lays down that profiling is subject to the rules of this regulation and that the European Data Protection Board, established by the regulation, should be able to issue guidance on that context. Article 4.4 defines profiling as any form of automated processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to a natural person, in particular to analyze or predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. In Articles 13, 14, and 15, targeting respectively the information provided to data subjects handing over their personal data, not handing over their personal data, or on the right of access by the data subject, it is required that there would be a meaningful information about the logic involved, as well as the significance and the envisaged consequences of such processing for the subject. Currently, the Directive lays down in Article 15 on automated individual decisions making the right to every person not to be subject to a decision which produces legal effects concerning him or significantly affecting him, based solely on automated processing. However, subject to other articles in the directive, member states shall provide that a person may be subjected to such a decision if it is taken in the course of the entering into the performance of a contract or authorized by law. It also stresses that the logic involved should be known by the data subjects, and that the right of access should be ensured. What should accountable data controllers get prepared for? First, controllers should not solely use automated means to make a decision that will produce legal effects or significantly affect a data subject. They should build a process to add human intervention and get data subjects' observations. However, automated means can be used in 3 cases: a contract with the data subject, specific provisions in EU or national laws, or data subjects' explicit consent. In all cases, adequate mathematical and statistical procedures should be used to correct inaccuracies. In the cases of a contract or of explicit consent, the data subject had the right to request human intervention. Additionally, automated means only cannot be used for special categories of data, such as sensitive data or criminal ones, and for data concerning a child. Controllers should provide systematic and meaningful information about the logic involved, the significance of the processing, the envisaged consequences for the data subject, and the existence of a right to access data. Finally, suitable safeguards also will include the right for data subject to express their point of view and obtain an explanation of the decisions taken based on automated means and profiling. The final question is knowing what will be the European Data Protection Board guidance regarding this new implementation of profiling.